Ladies and gentlemen, dear colleagues, dear friends, let me start panel A, which is located here in this grand saal. And the topic of this panel is triangular manner. Yes, because we will discuss the problem of the best child's interest. And we also deal with the issue of identification procedures and guardianship. 3 points which are very significant, and I will start on the basis of previous discussion about the concept, the best interests of the child. I got the idea that this is a great concept, which is a part of different forms of law. It is anchored, for example, in public international law at universal level. It means the Convention on the Rights of the Child, Article 3. This is also in primary and secondary legislation of European law. We mentioned Article 24 of the EU Charter of Human Rights, and also the secondary legislation. It means in refugee and migration fields, yeah, because there is reception direction, there is also return direction, and other pieces of European legislation. All the pieces protects the child's best interest. I mean that the concept is far-reaching and very anchored. Secondly, this is complex concept. Why it is a complex issue? In my opinion, there are 3 roles of the concept, and the roles determine the content of the concept. Firstly, from the point of view of substantive law, this is the substantive right of the child that his or her best interest has a primary consideration. Secondly, maybe this is very important, that this concept plays some collision role. It means if we have 2 different interpretations of any rule in the convention, it is necessary to prefer this interpretation, which is very close to the best interest of the child. And the collision rule, it is really very practical and also effective for the solution of interpretation collision. Third point, this is procedural design of the best interest of the child. And I mean that the procedural role of the concept we will discuss later on concerns the theology and as well the purpose of and goal of the concept. In my opinion, the concept is aimed at ensuring both the full and effective enjoyment of all rights recognized in the Convention and holistic development of the child. We should have in our memory, collective memory, this aim of the concept. And primarily, we will discuss the procedural role of the concept. Second, the question of identification procedures. We should differentiate between two kinds of identification procedures, between screening and assessment procedure. The main aim of screening is to get the information about the personal status of the child. It means, for example, the question of his name, the question of his or her age, the family ties, family status, also the ethnic or national position of the child, and other very important data concerning the child. The procedure must be child-friendly and child-sensitive. It means that if we communicate with the child, we should guarantee all the rights and the exercise all the rights of the child. Third point is about the guardianship. In Europe, we have different system of guardianship, centralized or decentralized system. In the Czech Republic, we, for example, have decentralized system and other countries because we established the offices of social and legal protection of children, and those offices functioning and operating in this field on the community level, and therefore sometimes the question is how to centralize and how to coordinate the activities all these offices. On the other hand, in Europe, we can see this decentralized system, and we will discuss this point. From the functional point of view, we should take into account that three functions must be exercised by a guardian. The first function concerns well-being of the child. It is Article 3 of Paragraph 2 of the Convention on the Rights of the Child. The second point, this is the best interest of the child, yes, because the guardian will represent the child not only in formal proceedings, but in informal action concerning the child. And the third function is about the representation. Yes, because the child has limited capacity. If we know that 4 capacities are governed, first is the legal capacity, second one is the capacity to legal action, third one, this is the capacity of accountability, responsibility, and fourth, this is procedural capacity. And the question is about the limitation of last 3 capacities. And therefore, this is the cogent reason for appointing a guardian in favor of the child. Maybe this is the 3 points. This is some general remarks about this, and our group, our panel, will discuss and will present these points during our negotiation. Firstly, I apply Christel de Craim, who is working as an acting head of Service for Criminal Police, Ministry of Justice of Belgium, and also he also serves as a member of the Bureau of the Ad hoc Committee on the Rights of the Child within the Council of Europe. and she will present some overview about the experience, her experience in this specific field.
Thank you, Chair. Let me first thank the Czech government to invite the CAHENF, or the Ad Hoc Committee on Children's Rights of the Council of Europe, to make a presentation here concerning this really urgent topic, if I may call it like that. Ladies and gentlemen, I will go into the topic of best interest of the child, guardianship, and age assessment. But first of all, I want to share with you some information concerning the work the Council of Europe does or has done in this field. The Council of Europe strives to protect and promote the rights of children through an extensive set of legal norms. These include the Convention on the Protection of Children Against Sexual Exploitation and Sexual Abuse, better known as the Lanzarote Convention, as well as the Convention on Domestic Violence and Violence Against Women, or the Istanbul Convention. And of course, there is the Convention on Action Against Trafficking in Human Beings. In 2014, the Belgian authorities and the Council of Europe organized a European conference on the best interest of the child. The aim was to shed light on a vague, though very central concept whose importance for children is unquestionable. So I'm very pleased with the fact that the Czech government took the decision to hold a conference on children where the best interest of the child has been so prominently in the discussion. In May 2016, the Committee of Ministers instructed the newly established Ad Hoc Committee on the Rights of the Child to make proposals concerning standards on legal guardianship and age assessment. Work is underway to draft a recommendation concerning guiding principles and guidelines for an effective guardianship for unaccompanied children in migration. The drafting group met last week and we had a very fruitful discussion. We're going slowly, that's true, but we're going forward. Now, the work will be completed in the first half of 2018, and the CAHENF will also draft guidelines on age assessment procedures to assist states with the task of transposing these principles into concrete procedures that respect children's rights. And this work is planned to be completed for the end of 2018. In March this year, the Lanzarote Committee, who monitors the Lanzarote Convention, brought out a special report concerning protecting children affected by the refugee crisis from sexual exploitation and sexual abuse. And last week, on the 20th September, the Council of Europe published also a report on age assessment procedures in Council of Europe member states. I saw that there were copies lying on the table outside. It is the fruit of a literature review and a survey of practice in 37 member states. Now, we are here today because many European countries are facing an increase in the number of children arriving with or without their parents. Due to this situation, the rights of children to development, the right to non-discrimination, the right to a life free from violence, the right to express their views and to participate in the procedures affecting them are put under pressure. Some countries are using detention as a solution to try to cope with the mass migration and are detaining children, unaccompanied children, and children with their parents. I believe that there is no good reason to do this. By detaining children in a migration context, states are violating the rights of children and are putting them in a risk situation. Stating that this is in the best interest of the child is manipulating the flexibility of this concept. The Committee on the Rights of the Child indicated in its General Command number 14 on the right of the child to have his or her best interest taken as a primary consideration that the vagueness of the concept can lead to manipulation. That is what is happening in this kind of situations. No matter their age, no matter their sex or where they come from, unaccompanied children are particularly vulnerable to human rights abuses and are in need of additional protection and safeguards. And one key safeguard is the prompt appointment of a guardian to act in the best interest of the child throughout their interaction with the state. An effective guardianship, taking into account the best interest of the child, plays a key role in dealing with the problems which arise when unaccompanied children are arriving on the territory of a state. Taking as a starting point the threefold legal nature of the child's best interest, states can make a difference when implementing a guardianship system. Mr. Jílek already explained the threefold legal nature of the child's best interest that should be understood as a right, a principle, and a procedure. It is the right of a child to have his or her best interest assessed and taken as a primary consideration, and the guarantees that this right will be implemented whenever a decision is made concerning a child. If a legal provision is open to more than one interpretation, the interpretation which most serves the best interest of the child must be chosen. Best interest assessment or best interest determination is required when a decision is to be made that will affect a child or children as a group. States must assess whether an action or a procedure would be in the child's best interest. As the best interest of the child is a primary consideration, not the primary consideration, it cannot be taken out as a single issue. The Committee on the Rights of the Child stated clearly that there is no hierarchy of rights in the Convention. All the rights provided for therein are in the child's best interest, and no right could be compromised by a negative interpretation of the child's best interest. Thereto, the best interest of the child must be linked with the right to be heard. How can you say that you're acting in the best interest of the child if you don't take into account what the child has got to say? The best interest of the child must be linked with the right not to be discriminated, the right to develop, and so on. As I already mentioned, unaccompanied children are vulnerable, not only because they are separated from their parents or from caregivers, but also because they are on the move. These children may have been confronted by sexual and gender-based violence and abuse, exploitation, physical, psychological harm, smuggling, or trafficking, and so on. Detaining of unaccompanied children only aggravates these vulnerabilities. An effective guardianship constitutes an essential safeguard for the protection of unaccompanied children. Now, there are many issues to take into consideration when we talk about guardianship. The prompt appointment of a guardian is considered to be very important. As soon as the guardian can be in contact with the child, the guardian can provide him or her with the necessary information in a child-friendly manner. He or she can explain the procedures to the child and can start building up a relationship of trust. The Council of Europe group of experts on actions against trafficking in human beings, the GRETA, stated that the prompt appointment of guardians for child victims of trafficking is also a key safeguard to break the link with traffickers and protect children from going missing. The independency of the guardian is another fundamental principle. The Lanzarote Committee highlighted in his report that the appointment of an independent guardian is a preventive mechanism to protect children from sexual abuse and exploitation. Independency means that not only the guardian should be independent in the actions and decisions he or she takes at safeguarding the best interest of the child, it means also that states should ensure that each guardian is independent from some services or departments. In particular, guardians should not exercise any responsibility regarding a child that could be understood as a potential conflict of interest. An example in the context of detention would be the appointment of an employee of the detention center or the head of the detention center as the guardian of the detained child. Such a person cannot be impartial. There is necessarily a conflict of interest in that case. Guardians should be qualified and receive training in identifying the needs of children and potential risks children run. The guardian should facilitate the access of children to help psychological care development, but that means, of course, that the state is providing education, psychological care, health, and so on, because sometimes we see that children or unaccompanied children are not entitled to this kind of care. Qualified and independent guardians who build up a relation of trust with the unaccompanied child, taking into account their views, should work out a durable solution in the best interest of that child. Guardians build a relationship of trust with a child. Their role is therefore wider than that of a legal representative. The guardian must operate within a relationship of trust in order to be able to take action on behalf of the child and effectively safeguard their best interest. Building up a relation of trust with an unaccompanied child is not possible when the child is detained. Detention raises barriers to the respect of the best interest of the child because it renders the child more vulnerable. The child is not protected as he or she should be and is not only physically detained, but his development is put on hold. In detention, children may face difficulties contacting or meeting with their guardians. Guardians must be able to communicate with the child at any time. Where the child is unable to express their views, their guardian should ensure that their best interests are being represented and respected in all proceedings concerning them. An effective guardianship is only possible if states establish a competent authority or agency with responsibility towards the management of the guardianship. This authority should recruit, train, monitor, and support the guardians. To keep a child safe, though, he or she must be recognized as a child. This seems logical, I suppose, but it is not necessarily the case. Age assessment procedures are too often used as a part of a normal procedure to identify a child. Age assessment procedures can indeed resolve doubts about the age of an individual. It is in the best interest of the child to be officially recognized as a child, as certain safeguards, protective measures, and rights are in place in states for children and unaccompanied minors. The best interest principle should guide the age assessment procedures. Guardians should protect the best interest of the child throughout age assessment procedures to ensure that, first of all, the presumption of minor age is taken into account so that he or she is treated as such. Secondly, the starting point should be to try to conclude that he or she is a child, not to try to prove that he or she is an adult. Thirdly, the child is not a victim of discrimination in referrals to age assessment and during the procedure. The child has the right to express their views at every stage of the procedure. This includes expressing their informed consent to procedures and examinations. and if they are unable to give informed consent, their guardian may be able to consent on their behalf. Therefore, states should inform children on the reasons why they are using an age assessment. If a child refuses to participate in the procedure, the competent authority should seek to understand why. They should not draw adverse inferences from this refusal. Professionals who do or who conduct age assessments should be trained and competent, and children should have the right to an effective remedy and should be informed of complaint mechanisms. If age assessments are done in a not so good way or bad way, children can be identified as adults and can be detained with other adults. Age assessment is sometimes also used to make a difference between a category of children, like say, under or above 15, under or above 14, because it seems that some children receive more protection than others. How can we explain that not all children are equal? In age assessment procedures, a guardian should have a safeguarding role. Therefore, conflict of interest is particularly acute where referral to age assessment is concerned, as the staff in the detention center may have a vested interest in the outcome of the age assessment. I will conclude. The Greta identified a number of shortcomings in member states where guardianship procedures are in place but are so lengthy and cumbersome that in practice staff cannot provide the advice and protection necessary. Therefore, it is recommended that as soon as an unaccompanied child is identified, a guardian is appointed to act in their best interest, take the necessary steps to establish their identity, and make every effort to locate their family, if this would be in their interest. The Lanzarote Committee recalled in his report, the guardian is an independent person who safeguards the child's best interest and general well-being. The committee considers that the guardian plays a key role in building up trust with the child and may enable the child to disclose sexual exploitation and sexual abuse. The CAHENF started its work on guardianship and age assessment, and as said in the beginning of this presentation, will finish it in 2018. I'm personally convinced that they will follow the same path as the Lanzarote Committee and the Greta, and that the best interest of the child is seen as the guiding star through the whole drafting. A decision that is in accordance with the best interest of the child not only takes in account the child's current interest, but will also estimate what the future consequences of the decision will be for the child's life. By following this principle by guardians in the guardianship and in age assessment procedures, children's rights will be fully protected in decision-making procedures involving unaccompanied children. I thank you for your attention.
Thank you indeed, Christel, for the presentation. The presentation brings in-depth analysis of guardianship, as well as some conditions for guardianship. And now we can move on to our guest, Stamatina Poulou, a senior investigator of the Office of Greek Ombudsman, and she is also very heavily engaged, in the protection of children's rights. Please, the floor is yours.
Thank you, Chair. First of all, on behalf of the Greek Ombudsman, I would like to thank the organizers of this conference for the honor to invite the independent authority to present the situation in Greece about the guardianship and the best interests of the child. My presentation will be short, unfortunately will be short, because till now the country haven't managed to put in force the special law about the guardianship of minors. So, according to the UNHCR figures, approximately 38% of incoming third country nationals only during the January till August 2016 period were minors, whereas in March of 2017, according to the updated statement by the same agency, the estimated numbers of unaccompanied minors in the country amounted to 2,100. The estimate of this number is based on the analysis of the referrals to accommodation centers of the National Center for Social Solidarity, which in Greece we call it ECA. In 2015, there were 2,248 requests in total to ECA for referral to accommodation centers, compared to 2,390 requests submitted in 2014, although, as mentioned above, the number of new arrivals in Greece was nearly 11-fold in 2015 compared to the previous year, because in 2015 we have these enormous, huge flows from the east borders. Finally, during the first months of 2017, it is claimed that there was a relative increase of the arrivals of unaccompanied minors through the land borders with Turkey. Where they live, these unaccompanied minors in the country? The unaccompanied minors, according to our laws, living first within the reception and identification centers under a regime of relative freedom, and such places are in Chios, in Kos, in Leros, and in Samos, or restrictions, or places where we have restrictions of freedom with or without possibility of daily exit. Such places we have in Moria in Lesbos and in Phylakio in Evros in the north of Greece. With the purpose of their registration and identification, they are detained there, as well as their protection until their referral to accommodation centers or safe zones, safe spaces, that are places of temporary and supervised accommodation. Secondly, they could live in open temporary accommodation facilities according Article 10 of Law 4375, and these centers, we call it camps. Thirdly, in accommodation centers for unaccompanied minors, in shelters. And last, in safe spaces, safe zones within the open temporary accommodation facilities. And now, a few words about the best interesting assessment. As the best interest is a general principle which should guide authorities' actions and decisions concerning children, it must be defined by the lawmaker in relation to different areas concerning children. The concept must be composed of two main aspects. On the one hand, it's a general principle which has to be taken into consideration in law, policies, and decisions related to children. And on the other hand, it's an individualized procedure that must adapt every child to his maturity, family circumstances, cultural context, sexual and emotional abuses, lack of families, etc. A proper guardian shall make decisions regarding care, education, health, and welfare of the unaccompanied minors. For actions affecting children in general or specific groups of children of concern, such as data collection, planning, resource allocation, project implementation, monitoring, or development of guidelines and policies, the best interest principle requires that due attention is given to their specific situation and protection risks. All these are in UNHCR guidelines on determining the best interests of the child. Measures will include consultation with children through participatory assessments that are systematic, age-appropriate, and gender-sensitive, the collection of data by sex and age, giving primary consideration to the best interests of the child in resource allocation, the insertion of child-specific aspects in guidelines, policies, country operation plan, sub-project agreements and standards operating procedures, and many others. Special provisions according to the Greek law of the best interest as a basic principle governing all the relevant issues exist in the law 4375 of 2016, it's Article 45, Paragraph 8, and Law 3907 of 2011, Article 20. Plus, I have to stress that also we have a provision of best interest in the Greek Civil Code. Now I'm passing to the issue of the age verification, because it's an issue that is very much connected with the best interests of the child. It is a known fact that the majority of third country nationals entering the country mainly from its east borders, from Turkey, lack any documentation, which gives rise to serious problems inter alia in the identification of unaccompanied minors. Today, after enforcement of joint ministerial decisions 9082 of 2016 and ministerial decision of 2013, instituted programs for the medical check, psychological diagnosis and support in relation to third country nationals arriving without documentation in first reception facilities, first of all. Later, the asylum seekers, the second one, presidential decree, concerns the asylum seekers. The age of unaccompanied minors is verified through a three-phase procedure. The verification of minority age at the first phase excludes the second one. If the psychologists, they examine the child and they agree that is a minor, so there is no need to proceed to the medical examination. So and so forth, making the medical administrative procedures and problems check the last phase of the procedure. While drawing the 2017 report of the Greek Ombudsman, the verification of age appears to still be based mainly on the medical assessment, unfortunately. The medical assessment carried out at the hospitals according to a standard method that includes an X-ray and a dental examination, without recording the method followed or other information, while the clinical assessment of the anthropometrics figures and the psychological assessment is either absent or limited in the country. This makes more difficult the further verification of the scientific correctness of the assessment, as you imagine. In conclusion, one could claim that the implementation of a reliable system for age verification by adapting specific guarantees remains a goal to be attained. Now I'm passing to the presumption of minority. In practice, we observe the phenomenon where third country nationals who have been registered as adults claim minority at a later time after their initial, they have been in the country. In such a case, they are referred to public hospital departments for medical examinations, as described above, but even after they raise the claim of minority, they continue to be treated as adults, remaining in the same detention spaces as them. Also, even if the poses documents proving their age, they are not taken into consideration when they lack validation by a competent authority of the country of their issue. Finally, it is worth noting that the cases referred for medical examination often encounter great delays from the time the claim is made until the actual conduct of the examination, resulting in their reaching the age of majority in the meanwhile. The system of guardianship in Greece. The shortcomings of the Greek system for the protection of unaccompanied minors are apparent also in the matter of guardianship. Up to now, the duties of temporary guardian are undertaken mainly by the public prosecutor of the area where the minor was found, as well as persons from the accommodation facilities, after appointment either by a prosecutor's order or a court decision. Today, there is a relevant provision in Article 19 of a Presidential Decree 220 of 2007, stating that the competent authorities shall promptly take the suitable measures in order to ensure the necessary representation of the unaccompanied minors, and to this end, the competent authorities inform the juvenile prosecutor, and where there is none such, the competent local prosecutor of the first instance court. This, the local prosecutor, acts as a temporary guardian and takes the necessary steps in order to appoint a guardian to the minor. It should be noted, however, that the provision is interpreted quite strictly by certain prosecuting authorities, whereas the practical inability of the prosecutors to exercise the duties of a guardian is also recorded. In practice, the large number of the unaccompanied minors renders impossible the exercise of the duties of the temporary guardian by the local public prosecutor, whereas the assignment of guardianship to members of the accommodation centers, because also there is this possibility, where the minors are living, poses the risk of a conflict. However, the absence of a guardianship system has been recognized both by the European Court of Human Rights in its decision dated of 2011 in the case of Rahimi versus Greece, and also in a report of the Council of Europe's Commissioner for Human Rights, underlining on the one hand the dysfunction of the institution, and on the other hand encouraging the Greek authorities to review the relevant laws. To this end, there is a draft law pending at the Ministry of Labour, Social Solidarity and Social Insurance, which has not yet been brought for voting to date. A few words about the legal system of the Greek Civil Code for guardianship generally, not only for unaccompanied minors. According to the Greek Civil Code, a minor shall be placed under guardianship where neither parent has nor can exercise parental care, and when the court has appointed a guardian pursuant to Articles 1532 and 1535. The organs of guardianship are the court, the guardian, and the supervisor council. A guardian shall have, subject to the conditions laid down in the provisions that follow, the duty and the right to take care of the minor's person, to administer his property, and to represent the minor in any legal transaction or court action. With regard to any disagreement among several guardians, the decision belongs to the supervisory council. At the request of a guardian who disagrees or any other person having lawful interest, the court may decide differently. The competent social care authority shall assist the supervisory council in its task, providing to it on its request information relating to the manner in which the guardian fulfills his duty, as well as the authority's findings concerning the personal condition of the minor in general. Before any decision by any of the organs of the guardianship, such organs must, with due regard to the minor's maturity, take also consideration of the minor's opinion. Every decision by any organ of the guardianship must aim the minor's interest. Guardianship shall cease with the minor attaining the age of majority or with his death. The court shall, at the request of the Supervisory Council or even on its own initiative, decide the cassation of guardian's function on a serious ground, in particular if the court considers that the continuation of his guardianship might imperil by reason or neglect of his duties. And now, the legal frame of guardianship, especially for the unaccompanied minors. The law 3907 of 2011 foreseen the establishment of a first reception service and a new asylum service. The establishment of the first reception service sets first receptions and screening procedures as the key issue of migration management in order to allow for further treatment depending on the case. Plus, the commencement of newly established civil new asylum service on June of 2013. In the past, the claim submitted to the police, and the Greek Ombudsman has put a lot of pressure to the government to change this law, seems to have extended access not only to asylum, but also to other services of support through the gradual establishment of a referral mechanism between the asylum service and civil society organizations. Greek legislation with Presidential Decree 61 of 1999 provides for the appointment of the public prosecutor as a temporary guardian. What is more, the adoption of Presidential Decree 220 of 2007 foresees that the public prosecutor acts as a temporary guardian of the minors and takes the necessary steps for the appointment of a guardian of the minor. In practice, public prosecutors delegate the responsibility for the care and protection of minors to managers or social workers of the reception centers. Unfortunately, these facilities are neither equipped nor adequately staffed to cover this gap. Some conclusions. As we mentioned above, the Greek legislation provides for the appointment of temporary guardians, the public prosecutor. Nevertheless, their protection is not guaranteed due to the prosecutor's excessive workload and the number of minors. As the daily acts that require the consent of a guardian are numerous, the absence of a special body of guardians has been characterized by a variety of human rights organizations to have implication on all aspects of the protection and exercise of their lawful rights, especially for their integration into Greek society. It is obvious the draft law for guardianship for unaccompanied minors to be voted and implemented immediately. Of course, the vulnerability of minors should be viewed in context of the Greek reality, namely the deficiencies of the asylum procedure, the limitations of the country's welfare system, and human trafficking issues. But also, we have to remember the UN Special Rapporteur on the Human Rights of Migrants, who recommended to the Greek authorities after his last country visit in Greece in May 2016. Address as a matter of priority the issue of unaccompanied minors, develop a substantial and effective guardianship system, ensure guardians underwent the necessary professional training, have the experience, expertise, and competence, such as social workers, and are appropriately supported with the necessary resources. Thank you for your attendance.
Yes, thank you indeed for the presentation, the Greek situation in the field of the best interest of the child, identification procedure. It means the question of the age assessment proceedings and the question of the guardianship and the specific situation which is regulated by law. Now, I see on the screen 12 top questions, but I open the floor for everybody. Please to comment and to raise question to our panelists. Please introduce yourself and the institution.
Okay, good afternoon. I'm Antigone Angelaki from Metadrasi NGO in Greece. I would just like to compliment Mrs. Poulou's intervention concerning guardianship in Greece, and maybe ask a question of whether, we should also mention Metadrasi's effort for a guardianship network in Greece. Of course, it doesn't reach the maximum capacity that the public prosecutor has according to the law, but I think it's an effort worth mentioning with, 53 members of the guardianship network deployed all around the Greek territories, receiving guardianship acts and authorizations from the public prosecutors in order for the children to have access to their rights. So I just wanted to make this short comment to provide a better picture of what is going on in Greece at this point until the legal framework is put into place, the new legal framework.
Indeed, for the additional explanation, but...
Thank you very much, Antigone, for your comment. I didn't mention the NGOs because as an independent authority, I have to stress what the state does in this issue, in this topic of the guardianship. But of course, yes, we have NGOs, we have Metadrasi, and we have this program, and thank you for...
Perhaps from the end, yes, I see the question, should a member state put in effect mandatory legal representation of children under 18 years of age? This is for both. Yeah, please, who will be the first?
In the Greek Ombudsman, we totally agree with that because for us, every person under the age of 18 is a minor. So in this option, we have to have a legal representative, mandatory legal representative, and not to make this distinction between the minors under 15 or 16 and the minors from 16 to 18. Yes, we agree, and we have some reports about that. We have written something like that. That to be mandatory to have a representative, a legal representative, every minor.
Every minor?
Every minor, under the age of 18, yes.
Okay. Question number 9. Do you think that there is a positive obligation of states under Article 8 of the European Convention on Human Rights or Article 3, Paragraph 1 of the Convention on the Rights of the Child to include guardianship in their domestic law?
Thank you. I certainly believe that if you include it in your domestic law, it would be better. Although you can invoke it, Article 3 of the CRC directly, I believe that you should have it in your domestic law because it will be more convenient for the child. At least that's the way we have been doing this in Belgium, and I believe that it's the right way to go forward.
Already said that Article 8 of the Convention on the Rights of the Child is, the concept is very open and very dynamic and very flexible, but the question is about if we can deduce, yes, from the content of the rule, from the disposition of the rule, the positive obligation. But there is the possibility, yes, to do it in this respect. A further question is here on the table. Should there be a maximum caseload for people charged to be a guardian of children so that they can really be available when the child needs them?
First of all, I want to stress out that there are different kinds of guardianships. You have member states who are working with volunteers, and you have member states who work with professional guardians. If you're working with volunteers who are a guardian and who have a full-time job, you can imagine that it will be very difficult to have like 20 pupils to try to build a relationship of trust with. If you are a professional guardian, then it's far more easier to have like 20 pupils. So you should make a difference there. But then it depends also who the guardian is. In some member states, it seems that, for instance, it's the prosecutor. Well, I know how the prosecutors work in Belgium, and the prosecutors who are specialized in juvenile affairs, they're very committed to their work, but I don't believe they have really enough time to build up a relationship of trust with their pupil. So, should there be a maximum caseload for people? Yes, there should be. It cannot be that one person has 300 pupils. I mean, that's not thinkable. The caseload should be perhaps 25, 20, but let us not exaggerating, because I don't believe that you can do your job if you have too many people to care for.
Okay, question number 7. Okay, do you think that guardianship would be more effective if undertaken by a state or non-state NGO body?
I don't know the answer, if it is better to undertake the guardianship from the state or from the NGO. The thing I know is that if NGOs undertake this role, I think the state must have a supervision, a very strong supervision, and also this role must be realized in specific laws and in specific provisions, because otherwise we are not as a state leave every NGO or the NGOs to do what they are going to do, because we need to have some specific guarantees about the role and the mandate of the NGOs. So I believe that if the state is unable to undertake this load, the NGOs must undertake it, but under the supervision of the state.
Thank you. Now, on the screen, question number 6. How can states intervene when the parents act contrary to the best interests of their children?
Okay. The states, according to especially as I told you before, the Greek Civil Code has some provisions when the parents acting contrary to the best interests of the child. There is a possibility the child to leave and to enter into special centers. shelters away from the parents. If the parents, they don't conform with the best interest of the child. We have such a provision. The problem with the unaccompanied minors is that we have such a huge amount that the civil code, we could not adapt in these cases the civil code. So we need a special law about the guardianship of unaccompanied minors, because the provisions are made only for the other kind of children that they have families in Greece.
There is also the possibility to appoint very promptly the special guardian for the best interests of the child, because he may focus on this specific issue sometimes, yes, the specific guardian. Okay? Yeah? No? Please.
Thank you. My name's Robin Sampson. I work for the International Detention Coalition. I actually have two questions. One is, I understand that often children are detained while age assessments occur. So I was just wondering if the panel could reflect on where children could be placed while these procedures occur so that they maintain freedom of movement. And secondly, I was just interested in knowing whether these procedures apply to minors who are affected by Dublin mechanism in Europe. So are they excluded from being considered for guardianship, or do they have their best interests protected while going through the consideration of transfer to another member state? Thank you.
Okay, this is very specific issue, yes, concerning Dublin number 3 and also the application, the Dublin rules concerning the child and his or her placement in custody. Who will be first, Christel or Stamatina?
If I understand well, if the best interest assessment, if the authorities take care of the best interest of the child in order to apply the Dublin regulation. If you ask me, yes, of course they have to take consideration of the best interest of the child, but I'm not sure if is this the Greek reality, if that happens in Greece. I'm not sure, because we see also in the office of the Greek Ombudsman we have some claims that they persuade completely the opposite of what I told before, that the best interest of the child doesn't examine at all. And I don't, your first question was about?
It was about where children can live, whether they can be in open facilities rather than in detention.
The placement, yes.
Yes.
It depends. Some of the children, they are living in the open facilities, in safe zones, as I told in my presentation, in safe zones in the open temporary centers. But also we have, there are minors that they are being detained in the option of protective custody, we call it, and there are minors that are kept in police stations, and of course it's a detention, it's detention centers, yes.
I'm not sure how it works in the different member states, but I can say that in Belgium, the children are staying in open facilities while they are being assessed. So there is no need for me to detain them. I think people are scared they will be missing or they will be running away. But if you have a guardian appointed, and if he or she explains to the child why these procedures are taking place in a child-friendly manner, in a way that he or she can cope with the reason why, then I don't see any reason why the child should be detained. After all, he should be considered as a child and not as an adult.
Thank you. I'm Nuala Mole. I'm sorry for taking the floor today, as I will be speaking tomorrow, so please forgive me. But there are 2 points I think very important to make. One is that the European Court of Human Rights ruled last year in the case of Abdullahi Elmi and Abu Bakr against Malta about the undue lengths of detention of children who were being kept in detention for age assessment, and it's a very instructive judgment for anybody who's concerned about children being detained for age assessment processes. And the other point I would like to make is that there are 2 very distinct responsibilities. One is the responsibility of the guardian of children, and guardians are appointed to be the carers of and voice of the child throughout a situation where they are not able to be their own voice and to look after their own interests. But that's a very different role from the role of their lawyer or their legal representative. And children in these situations we're talking about need both guardians and lawyers, and it will be rare that one person can fulfill both those roles, and we need to recognize that.
Thank you indeed for the comment, yes, because this is very analytical comment concerning distinct responsibility of the guardian and the legal representative. The question also, the legal assistance, is something different, yes, because the legal representation concerns the specifically proceeding before the court, yeah, and if we have the administrative issues, for example, and this is the specific situation, but Christel is
yes,
ready.
I totally agree, and when I see the next question on the screen, who would be an ideal guardian, and do you think that attorneys could serve as guardians of migrant children, then yes, they can, but they cannot at the same time be their lawyer as well. So in Belgium, we have lawyers who are guardians, but they're not operating as the lawyer of the child. Who would be an ideal guardian? Again, in Belgium, we see that we have a lot of people who are retired lawyers, retired policemen, retired prosecutors, whatever, but retired people who have the time and who are committed to these children who are a guardian. We also have professional guardians, so we have a mixed system. The ideal guardian is someone who is independent and who is qualified and who received training and who is monitored and who is supported by his agency and by the state.
Yeah, one point is also important is this interdisciplinary approach, yes, to the child, yeah, because this is not only the legal issue, this is also psychological and other issues, and therefore this is sometimes necessary that the background, professional background of the guardian will be so broad and to include so many fields, not only one, the legal issues. Okay. Please.
Thank you. Just a small comment on the question on the Dublin transfers and the best interest determination. Concerning Mrs. Poulou answer as far as the Greek authorities are concerned, this, as you know, there has been the judgments of the European Court on Human Rights, MSS versus Belgium and Greece. In this case, it was a Dublin transfer. It was not a minor, but yet it was considered that it was a violation of, among others, of Article 3 due to the circumstances. This decision has not ceased to exist. Greece, as far as I can tell about Greece, Greece is still is under supervision from the Committee of Ministers concerning MSS. So it's not a matter of transfers from Greece to other European countries, since Greece is the first point of entry and it's the other way around. As you know, the Dublin transfers are supposed to restart towards Greece, And I'm not sure that this is compatible with the MSS versus Belgium and Greece decision, as far as at least Greece is concerned, since it is still, as I said, it's under supervision from the Committee of Ministers. It has not been closed. Conditions have not seemed to be dramatically changed since the decision was issued. So I'm not sure that in case of returns of children under the Dublin regulation from other countries to Greece, this would be compatible. Yet, we did have one, as far as I know, from Sweden to Greece of a minor, and I'm not sure that then the best interest of the child and in general Article 3 considerations have been examined. So.
Thank you indeed for clarification, different structural points of this issue. Nobody is? No.
In the back.
There is a specific question to Madame Poulou. Since Greece is one of the key migrant entry states, how come there hasn't been more progress when it comes to protecting the rights of migrants?
Allow me to say something that we are now in the heart of Europe, here in Prague. The problem of the refugees is not a Greek problem, it's a European problem. So if Greece fails to confront this problem, this is also a failure of Europe. In my opinion, and also in the opinion of the Greek Ombudsman, I transfer the opinion of the Greek Ombudsman, the European bodies will have to pressure, to empower the relocation system and the reunification system as far as we are talking about minors. I think these are the paths to find a solution. Otherwise, if we don't think in the ways of integration all this population, I think we are going to have a problem, and we are not compatible with the human rights, our solutions. Yes.
Okay. Only from a historical perspective, in the very beginning of the 20th century, in the 1921, former Czechoslovakian Ministry of Foreign Affairs, Mr. Beneš, declared that migration flow from the Turkey, mainly Russian and Armenian migrants, that this situation needed to be, or to have some specific European action and reply. Yes, and there is some similarities, not analogous situation. Okay, so please.
Just to complement Ms. Rossidi's answer for the best interest assessment of children also going from Greece to other countries for the purpose either of relocation, family reunification, or transfer in other contexts, such as a project that was run with the UK government. The best interest assessment is the first step in order to initiate procedures for transfer. So the answer is yes. And in specific cases, there's also a best interest determination that is approved by a panel in which the member of the Guardianship Network, UNHCR, and I believe the Social Center for the Greek ECA, the National Center for Social Solidarity also participates. So in all the cases, okay, I'm not going to say in all the cases, but in the majority of cases, both a BIA and a BIT are performed before transfer.
Again.
Just another comment, which is to support what Stamatina Poulou said, that the problem is European and not just Greece. The administrative court in Wiesbaden just a couple of weeks ago ruled that the problem with transferring children who were detained in Greece to their families in Germany, children who had been approved by the Greek Dublin unit for transfer to Germany, and the fact that Germany was putting a cap on the number of children who could go into Germany under the Dublin regulation, which is totally illegal. Fortunately, the administrative court in Wiesbaden struck this down and held that Germany was responsible for what was happening to these children. Thank you.
Thank you again. Ladies, yes. In the end of the room.
Yeah, that's me. Thank you very much. I work for the Greek Ministry of Labour. Just a very brief comment to what was mentioned earlier, that there have indeed been a few steps towards a better alternative as regards guardianship and where the establishment of safe zones for unaccompanied children, and the fact that I have some data, an update that was that is from the ECA, the National Centre for Social Solidarity as well, that was mentioned earlier. These are operating in cooperation with NGOs, with the Greek Ombudsman for the Child, with the support of UNICEF and the UN High Commissioner. So there has been some progress, and I thought it would be a good idea to mention that. Thank you.
Thank you again. Could you explain us what does it mean, the safe zone? Yes, what is protected? Yeah. Okay.
Yeah, of course.
The safe zones in the open temporary in the camps was created because until then the minors, they were kept under protection custody in police stations and such places that they were under detention. So because we didn't have as a country special shelters in such a number that the number of the minors needed, they created, the state, these special safe zones in the open, in the camps. The thing is that I want to notice that it was an effort that the General Prosecutor of the High Court and also the Greek Ombudsman, we put an effort, but I want to stress that we don't participate in the operation of these safe camps. Yes, the Greek Ombudsman doesn't participate in the operation. We just put an effort to put in force this situation about the minors. Now, the safe zones, it was a solution, but it was a temporary solution. The minors, they could not, the unaccompanied minors stayed for a period of more than 6 months in such places because those places are open places. There are camps that also we have matters of safety. Of course, it was better than to be a minor in a cell of a police station, but this is not the proper solution. The proper solution is to have a guardianship, to have a guardian, and to be in a special shelter for unaccompanied minors. This, and I repeat it, is only a temporary solution. Yes?
Okay, fine. Fine, thank you. Okay, I have one question on the screen. This is for both ladies. Should there be specialized guardians for migrant children? Specialized guardians for...
I will not disagree with that. Of course, I agree. The guardian must be specialized. That is what I told you before, that according to the Greek Civil Code, we have provisions about the guardianship, but these provisions are not suitable for this kind of minors, because there are minors that they have a lot of psychological traumas. Sometimes they are being trafficked until to reach the country. Of course, they must be specialized, these guardians for the migrants.
Well, I can only say that I agree with my colleague, so...
Okay. There is the connecting question. Should the guardians undergo special training? This is very similar. For example, in the rights of the child, case law of, and the child psychology or asylum procedure.
Well, maybe I can say a little bit concerning the discussion we had last week in the working group on guardianship, we were talking about all the training and the qualification that guardians should have. And at one moment, we were saying that there should be supermen and supergirls, because they should know about asylum procedure, child psychology, children's rights. Are there indicators to say that they're abused? Are there indicators to say that they are victims of trafficking in human beings, and so on and so on? So, do they need special training? Yes, they do need special training. They should be sensible to know that children are in need, but that doesn't mean that they should try to ease or to make a solution for the children themselves. They should make sure that if a child is in need, or if a child is perhaps a victim of sexual abuse, that they can access, or that they can go to a specialized center, or that they go to a shelter when they are, for instance, victims of trafficking in human beings. They should know about the asylum procedure, but there I think it's important that not only the child has a guardian, but also has a lawyer who will guide the child through the asylum procedure. But they at least should know about it, because they should know how to explain it in a child-friendly manner to the child, what that asylum procedure means and what will be asked from them.
Thank you, Christel. Yeah.
Hello, I'm Melanie Teff from the International Detention Coalition. I wanted to ask Christel if there was any information on the delays in some states in appointing guardians, whether those delays were resulting in more children being held in immigration detention. If there's any correlation?
Correlation, I'm not sure. But it is true that in some member states it takes a lot of time to appoint a guardian, or they will appoint a guardian who is not really a guardian. I mean, for instance, in one member state it's the mayor of the town who is appointed over and over as a guardian, and he has like 300 pupils, but then he is not the real guardian, because he then appoints another guy or another woman to act as a guardian. So when will be the exact time that the child will see his or her guardian? It can take a week, would be nice, but it can take months before he or really is able to talk with his or her guardian. So yes, it's sometimes very lengthy.
Yeah, because 7 minutes remaining to the end. We have on the screen 1, 2, 3, 4 questions. One, how do we ensure that the appointed guardians will not exploit their position of power and cause harm to the child?
As I told you before in the discussion, I don't know who is going to be appointed to be a guardian, to be a public servant or an NGO or an individual. The one thing that I know is that the state must have a supervision over him, strong supervision over him, to have some rules, some acts, some protocols, and supervision. So I think this is the only way to avoid such situations of exploit their position of power and cause harm to the child.
Yeah, we need to speedify our dialogue. Question number 3, why would it be in the state's interest to give effective guardian to a child if his role is to raise a voice of a child, challenge domestic laws and practice?
That's a very strange question, I must say. I mean, that would mean that Well, for me, you're not acting in the interest of the child if you raise this question, but it's like shut up because otherwise you're annoying the state. I mean, I cannot explain it otherwise.
Okay.
If I understand well the question, in my opinion, it asks that if your role is to raise the voice of the child, why do you need an effective guardian? That is the question, yes? So, look, as I told in the discussion, a minor is a person under the age of 18. That means that always, if you are a minor, and according to the majority of the civil codes, you need to have a representative, to have a parental care. This hasn't something to do with the maturity of the child and the effort that us democratic societies give to create mature persons. So in this process, in this pedagogical process, you have to raise a voice of the child and to permit him to say his opinion or her opinion. But this has nothing to do, I think, with a system that a person under the age of 18 must always have someone that represents him or her. I think they are not in confrontation as a...
Okay. Question is about participatory assessment. It means Article 12 of the Convention on the Rights of the Child, the participation issues. On the other hand, the question of assessment, yes, these are the first proceedings. Maybe, in my opinion, the participatory assessment is because there is the right to be heard, that the child must be communicated, yes, and yes, because the child must express his story. Yes, it is very important. Otherwise, the assessment is without his voice, and therefore, this is the necessity to asking him. Yeah, okay.
And also you need some special protocols when you have all these interviews. You need because what we notice now, we see sometimes that the people, the servants, they are not well trained, and all these interviews are becoming in a more automatically way. Yeah. That it's not in the best interest of the child, of course. So we need to have these protocols step by step. Yeah.
Question.
It's for me.
For Stamatina.
Yes, it's Greece.
Yes.
It's
increase of numbers of accompanied children.
We're in the front of the scene. So it's about the public prosecutor office. Yes. Look, in my opinion, it's not a matter to strengthen the public prosecutor offices. To do what? To make more prosecutors about this? No, it's not there the solution. The solution, perhaps somebody could say that to make a special prosecutor for the unaccompanied minors. And also there is not the solution, because the mandate of the prosecutor is completely different. It's not the protection of the child. The prosecutor is handling the crime. It's his job. We need special services for the guardianship. The prosecutor is not the proper role to have the guardianship, even temporary, of a child. We need special services that they are oriented to the child protection. And the last one?
The last one. Yeah. This is the question. Very structured. How many issues covered? Okay. What should be specifically be in the law on guardianship of migrating minors?
I think that más o menos I have already said what should be in the law. What it be in the draft law, I'm not the proper person to introduce to you because it must be someone from the Ministry of Social Welfare. Or Maria, if she wants something to add. Mrs. Rosidou, Chairman. Mrs. Rosidou, I think, wants something to add.
We have only 13. Very speedy. Very fast.
I've worked a little bit on the draft law on the new system of guardianship in Greece. So it foresees a registry of guardians. I think the orientation is that they are all social workers or psychologists. There is a limit of children that one guardian can have. There is a supervision mechanism, of course, and there is also, let's say, a best interest determination procedure. So I can briefly say this. Let's hope that it will be voted finally.
Okay, we may utilize the coffee break, yes, for informal dialogue, because this dialogue is formalized now. Many thanks. Both. Thank you indeed for your presentation and very active approaches to answers. Fine. Thank you indeed, both participants of this panel. And now the break is about 30 minutes. It will be again the plenary session and reporting from a parallel thematic session. It means about 20 minutes. Thank you again and see you.